said everybody, including law students. Welcome to the inaugural podcast of the Law Student. Each episode, I'll explore a different topic in law from one of our many topics that we study at law school. Just trying to do something a little different here. Think of the show as somewhat of an outline, but with audio. An audio outline. Anyhow, I'm going to get right to it. This episode is dedicated to our favorite subject, civil procedure. We're talking about filing federal claims. Exciting, isn't it? I think so. Every day is good for civil procedure. Anyhow, we'll get right to it. So, what am I talking about here? Well, I'm talking about filing a federal claim. Pleadings. Initially, under Rule 8, just some quick notes before we get started. Remember that an allegation is a factual assertion. It doesn't mean it's the truth. If it were the truth, we wouldn't be calling it an allegation, simply a factual assertion. The first pleading is called a complaint, and a complaint must state grounds for federal subject matter jurisdiction. A complaint must also include a demand for relief, sometimes called the prayer for relief under Rule 8A3. The defendant's first pleading is called an answer. Yep, just like that. Simple as that. We have a complaint and an answer. Rule 8B and C. Now, the answer may include a counterclaim or cross-claim. Now, what is the purpose of all this? What is the purpose of pleading? Well, generally, you look to the case of Wright v. Miller. It's to give notice of the nature of the claim or defense. It's to state the facts. It's to help judges narrow the issues for litigation. It's also to help the advocates narrow the issues for litigation. And it helps courts throw out the bogus claims and defenses without the burden or expense of a trial. Now, how much a party pleads or has to plead depends substantially on the relative weight that a procedural system assigns to each function. Now, I'll let you know that I'm broadcasting this from the confines of my lovely law school dorm. So if you hear people yelling in the background, it's because they're reading torts right now. So let's get into it. A notice versus a fact statement. Now, some jurisdictions weigh notice, while others simply weigh the fact statement. Notice requires less detail than fact statements. So think about that. Notice requires less detail, and a fact statement requires a little more. Rule 8A2 stresses that you only need to make a short and plain statement of a claim showing that the pleader is entitled to relief. This is going to vary, as you'll see, through the different pleadings and the levels of those pleadings as we move on. Now, the defendants challenge the sufficiency of complaints. That's it. They challenge the sufficiency of the complaints. They don't actually attack, the allegations or whatever. Not at this stage. They challenge the sufficiency of complaints. An insufficient claim can be attacked in court by defendants' motion to dismiss the complaint for failure to state a claim. This is Rule 12B6. Now, I'm going to let you know real quick. Rule 12B6 is your friend. You need to know this by the back, like the back of your hand. By the back of your hand. That's funny. Write it on the back of your hand if that's what it takes. Rule 12B6 is your motion to dismiss the complaint for failure to state a claim. 12B6 motion is also known as a demurrer, depending on the jurisdiction you're filing your complaint in. And it must be filed prior, typically, to the answer. In other words, it should be filed as a pre-answer. Now, this isn't always the rule, but generally speaking, file this sucker before filing an answer, because if it's granted, you don't even have to file an answer. End of story. Now, it's important to know that the state law typically determines the element of each claim, which is the state uses the federal rules as an umbrella, and they don't go outside of the parameters set forth by the federal rules. They simply make up their own rules based on their suppositions of what the rule is, or are, if there's more than one rule. So, pleading begins by researching the substantive law. Why is that? Well, so you can actually state your claim. If you can't actually state your claim and you don't have the substantive law to back it up, you don't even have a claim. It's going to get thrown out. So quickly, review. Most federal pleadings consist of a complaint and an answer. Keep the common law principle in mind when thinking about this. In other words, think of, he stole my cow. Someone is alleging that someone stole their cow. The defendant says, no, I bought it. So the issue here is simply, did the defendant pay for the cow? That's it. And the complaint, it includes the issue and subject matter jurisdiction along with a prayer for relief. It must include those things. The answer is outright denial, or you can confess to it but plead a thing called in avoidance of liability. Typically minors do this. You can confess but plead duress, fraud, license, release. Release essentially says that the plaintiff released the claim in a settlement, meaning that he's already given up his right because of the settlement to even proceed further. So with that, we're going to get into our various pleadings. And here they are. We got equity pleading, code pleading, notice pleading, heightened pleading, and plausible pleading. Yes, all kinds of pleadings. I'm just going to start with equity pleading. I won't even go into some, try to make a joke about this. We're going to be serious, and we're going to get through this, okay? So in equity pleading, it's decided by the bench, that is without a jury. It is done to seek an injunction via, say, a bills of complaint, when the plaintiff shows he or she had no remedy at law, in order of decree, ordering the defendant to do something or refrain from doing something. It has the potential, when the law has no remedy, and to permit discovery or joinder of parties. We'll discuss that in a different podcast. Future one. And that's equity pleading in a nutshell. Now we're going to move on to code pleading, which basically was started in New York, essentially, under the Field Code, which was adopted in 1848, and soon thereafter adopted by more than a dozen states, essentially abolishing the common law pleading system that I gave you an example of earlier, and wiped the slate clean. The fact pleading within the code pleading, only facts are allowed. And why? Because it helped judges weed out the legally insignificant claims. Now, complaints of this nature must avoid legal conclusions and include only the dry, naked, actual facts. Federal Rules of Civil Procedure number 1 proclaims that the federal rules should be construed and administered to secure the just, speedy, and inexpensive determination of every action and proceeding. So, under a code pleading, the questions are simply, what are the facts, and what is the cause of action? And that, my fellow law students and other listeners, is the gist of code pleading. Moving on to notice pleading. Notice pleading requires a short and plain statement of the claim showing the pleader is entitled to relief. In our first case, which ushered in the era of notice pleading, Diaguardi versus Durning. This is the case of regarding the cases of tonic that I won't get into nor divulge because you should have read it by now. But anyhow, here's the rule that comes out of that. The court holds that it may take account of the law regardless of whether a party knows it or what the party says the law is. So in Diaguardi, the plaintiff filed a pleading which was handwritten, didn't follow any rules, and it was a little, iffy in terms of being cogent. or rather understandable. But the court still said that doesn't matter because he's stating a claim and he's entitled to relief based on the claim, whether or not he knows the law. Now, in another case, Doe v. Smith, the courts may infer evidence, which expands slightly, ever so slightly, on Diaguardi. The facts stated in a complaint are not necessarily true, keeping this in mind. That's why we call them allegations, folks. I'm going to keep saying that. But for the purposes of a 12b-6 motion to dismiss for failure to state a claim, the court usually assumes that these allegations are true. And if the facts are true, then the court should deny or allow the motion. A 12b-6 is decided only within the four corners of the complaint. Think of Diaguardi when you're pondering what that means and how the court was restricted to his complaint. The courts do not decide the factual disputes when ruling a 12b-6 motion. However, affidavits can be used to help with dismissing a complaint and can convert to a motion for summary judgment under Rule 56. Now, any disputes of material fact precludes summary judgment and sends the parties to trial. So the court only summarizes the undisputed facts. Which brings us to the Conley standard. Conley v. Gibson. You should know this case too. Actually, any case I mention here is one that you should probably know. At least that's what my professor tells me. I don't know what your professor says, but mine says, you gotta know these cases. She also says, every day is a great day for Civ Pro. Anyhow, the complaint should not be dismissed on a 12b-6 motion unless it appears beyond doubt that the plaintiff can prove that no facts in support of his or her complaint which would entitle relief. Again, you can't dismiss on a 12b-6, or a court can't. You can do whatever you want, but a court can't unless it appears beyond doubt that the plaintiff can prove no facts in support of his or her complaint which would entitle relief. So relief is more important, or the entitlement of relief is more important here than the actual complaint. It all comes down to, are they entitled to relief? And if so, you can't dismiss it. Inconsistent complaints may not be dismissed if the plaintiff is entitled to relief, simply put. Note here then the forms of pleadings, that is your rule found in Rule 10b, requires a number of paragraphs, each of which to be limited as far as possible to a single set of circumstances. Each count must be charged separate from one another. Diaguardi doesn't do any of that, but they still accepted, the courts rather, still accepted his complaint. However, and in light of Diaguardi, the pleadings must be construed so as to do justice. So in other words, with all that in mind, there's no such thing as a 10b violation, and it doesn't mean that there's a 10b, or rather, it makes it impossible to have a 10b violation which results in a dismissal. So that might be a trick question one of these days, something about a Rule 10 dismissal or whatever. Just, don't bite the red herring, and just remember, there's no such thing as a Rule 10 dismissal. Even if you submit the ugliest, the most out of bounds pleading to the court. And that, my friends, is a notice pleading. So, heightened pleading. Heightened pleading. Federal Rules of Civil Procedure, Rule number 9, imposes heightened pleading for allegations constituting fraud or mistake. A party must state with particularity, key word, it's a buzzword, with particularity, the circumstances, when, where, and how the fraud was committed. Leatherman v. Tarrant County exemplifies Rule 9. Now the reasons for heightened pleading are as follows. Simply to give fair notice. It's also to protect reputation, because the mere mention of fraud can absolutely destroy somebody. So it's to protect reputation. It's also to protect the public's money. See the Leatherman case. And also see the Leatherman's case for when the plaintiff